And we're live on YouTube. For once, we are on
Woo!
time, Sanjay. We make a live stream are like 15 minutes late because we're trying to figure it out, and it's kind of funny because both of us are Indians, and we can just destroy the stereotype that we're supposed to be good at tech. So, well, hey guys, welcome to the Area 51 live stream. We are joined by our favorite attorneys, Stephen and Brad. Uh, I'm sure all those who've been kind of passionate about immigration or just stuck in the immigration backlog would have heard the big news the last week where we've got the Chevron uh, deference that have been overruled by the Supreme Court. If you guys are active on X, everyone's celebrating there as if all our problems are done and green cards are going to be sent to all our houses by tomorrow. But
Yep.
Sanjay and I, being a little more pessimistic, we thought, hey, let's actually talk to the folks who know what they're doing and understand what impacts this has on the immigration system, whether it's good or bad. And maybe before that, just give a little background on what this ruling is and what we are potentially looking at. So, welcome to the live show, guys. Steve, Brad, good to see you guys again.
Thanks for having us.
Good to be here.
Yeah, Sanjay and I and Brad forgot to give Steven the memo. To be honest, I thought he'd be wearing his Team USA cricket jersey.
You know, I thought about it. I really did when we were texting about or on X about our golf scores and all that, taking for the debate, and I really thought, all right, I'm going to wear my cricket jersey, but I decided I'd look somewhat like the professional I pretend to be.
Hey, it's Steven. You've got quite a following on X, man. And just for the folks calling in, someone actually clicked on the live stream link that we posted with a question for Steven. And he was already responded and solved that guy's problem. And so you've got quite a following, man. And I've actually seen you live in your Telegram group as well. Thanks for everything that you and Brad do. Both of you are superheroes for the entire immigrant community. So thank you. Sanjay, you want to kick us off? You want to, I don't know, give everyone a quick, background on the Chevron ruling, and
So
we can just give it to the pros after that.
Yeah, so the thing is that I'm probably not the right person to go all technical on this because we actually have two lawyers. But I'm gonna try my best, and then Stephen and Brad, you can go ahead and chop me up with whatever I've said later.
Yep.
So basically, this idea behind the Chevron rulings. First of all, for those of you who think, what has this got to do with an oil company? It actually was a ruling with Chevron involved, I think in 1984 or somewhere around that time.
1984. Yep.
Yeah, and the idea, pretty much the gist of the ruling then was that that any time that there was some sort of argument against how, if there was some sort of a gap in a particular law that Congress did not foresee when they wrote those laws, the courts deferred to the opinions of the federal regulatory agency that was executing it, was a part of it, because they were considered as experts because they dealt with that sort of stuff every day. Now with the new ruling, the Supreme Court pretty much has said that that need not be the case, and it can be up to the court to decide. Now, that does not explicitly mean that courts suddenly become experts in, from semiconductors to immigration or whatever it is. There will be, expert witnesses and things like that. But that it was the basis for, I think, probably a lot of lawyers' entire careers itself, just that particular ruling on how they can, define arguments for and against the Chevron ruling. And so we have Brad and Stephen here because that might have some implications, especially when it comes to litigation for immigration-related stuff. I'm just going to hand it over to either one of you to probably give a primer on what could be there.
Stephen, you want me to lead off, or you want to?
Yeah, I was gonna say our resident
litigator,
our adjunct admin law professor.
Okay. Oh, okay.
So yes, I teach admin law as an adjunct at the
I didn't
law
know that,
school in my
Brad.
town.
I didn't know that. Wow.
Yeah.
It's also where I went, and so they feel bad for me. Like, come poison the minds of our youth.
You're like the Van Wilder of that college. Huh? You never left.
So you start day one in admin law, and the only thing these students know is, well, Chevron,
Yeah.
and you don't get to it until like the last 3 weeks of class, right? And interestingly, 1984, right? The plaintiff, or I shouldn't say that, the EPA administrator was actually Neil Gorsuch, Justice Gorsuch's mother. So that's kind of fun. But essentially, one of the things I think that's being lost on X right now is when Chevron actually came into play. Okay, so I do want to give just a little bit more of a background on like why it would come up in litigation and what it actually impacts and what it doesn't at all. So if there's a statute out there, okay, and the agency just applies the statute without a regulation, without a policy, without some sort of interpretation, okay, then Chevron has nothing to do with anything. Okay. It only applies, or used to apply, I guess, when the agency announced an official position and interpretation of an ambiguous statutory term. All right, now that's a lot of legal talk. So what does that mean? If the statute said stop at red lights, there's no ambiguity there.
Sure.
Right?
Okay.
There's no way for an agency to say, well, at magenta lights, you can go 10 miles an hour. At blue light, right? And if that happens, if there's a plain statute with no ambiguity, we never talk about Chevron. Okay. The reason I'm emphasizing this particular point,
I think I know where you're going with it, but
and I Stephen and I talk about this a lot. The last thing, the worst thing I can do is sell people false hope. Okay.
Yeah.
And X is full of false hope.
Yeah.
And before the podcast, I went back and reread the decision that relates to EB5 and trying to count, not count derivatives as part of the visa numbers.
Yeah.
It's a decision out of the DC Circuit. I believe it's called Wang.
Versus matter of Wang. Yep.
There you go.
Yep.
If you go and read it, Judge Walker, who is a Trump appointee and when he was growing up was the neighbor of Mitch McConnell, wrote that decision.
Okay.
And if you read it, he never once talks about an agency interpretation. He talks about the plain language of the statute, and the statutes control everything. And he finds no ambiguity in the words of the statutes. Chevron has nothing to do with it in that situation. Now, you could disagree. You could say, oh, it is ambiguous. But in today's world, that doesn't matter. And I should say,
that was one thing that I was hoping would change.
Well, and I guess I just point to that decision as a good example of, something where if you read the decision, the reason Chevron never comes up is because they say the statute is clear. It is like saying stop at red lights, and we're just applying the statute. Now, you can disagree with that, okay? And I think that's a fair disagreement. So let's say, back to our example, it said, the statute said, slow down for red lights. An agency could maybe come in and say, well, you need to be going 25 miles an hour, 100 feet away, 10 miles an hour, 50 feet away, and 0 miles an hour at the red light. Or you could say they need to be going, 10 miles an hour, 100 feet away, 5 miles an hour, 50 feet away. And there's a way to interpret slow down. Under Chevron, what the courts would do is they would say, okay, let's look at the statute. Is there a kind of spectrum of answers that could fall under this word? If so, as long as the decision fell somewhere within that reasonable spectrum, the court wouldn't do anything about it. And in the most hard to swallow cases, they would say, we disagree with that legal interpretation, but because it's within this spectrum of reasonableness, we're going to defer and we're going to let the agency control the policy. Okay? So in today's world, rather than having this spectrum, it's going to be returned that the court is going to say, here's the best interpretation, and that's the only interpretation. End of story.
And I think what makes it interesting from a litigation perspective, and I saw this from an attorney online, is that a lot of times Chevron, when you're challenging regulations, the agency gets a head start, right, on the litigation. It's you know, they've got to be reasonable, but they're kind of ahead, that their interpretation is good, right? And then it's up to the challengers to argue, no, they're so wrong that even Chevron, you know, given them the deference in Chevron, they're wrong. So I think this changes things where there's hard policies, regulations. And I'll tell you this has been one of my frustrations, and Brad and I are talking about it today with Twitter and news and all this. This doesn't mean the end of the rulemaking process. This, you know, I saw, hope you like clean water. The EPA can't do anything. That's not what this means. We can still go through rulemaking. It's just they're not going to get this deference that they chose the right decision in the analysis.
So are there any places where it is ambiguous and where you think this could actually potentially help the immigrant community?
That's a very open question. Like, I think, right? There's just two.
So talking about X, I will say the best example I saw of this was an attorney. I think he's in the Midwest. I really like him. His name's Matthew Hoppuck, and he cited a bunch of Board of Immigration Appeals decisions. So when we think of interpretation, especially in the employment-based side, we think regulations, right?
Okay.
But on the other side of immigration, where you're dealing with deportation, they have the Board of Immigration Appeals, and their decisions and their interpretations of the statutes used to get Chevron deference. And those can vary wildly from circuit to circuit and such. And so I do think, the term aggravated felon, what does that mean? Crime of violence. What does that mean? Right. But I will say, even there, with the new decision, it's not like the courts are going to decide it in a vacuum. They're not going to say, "Oh, you made a decision, immigration judge and Board of Immigration Appeals. We're not going to read it. It's pointless. It's worthless." Right? No, they're going to read it. It's just not going to carry dispositive weight. But if it's well reasoned and it's sensible, it will carry persuasive weight. And so, like Steven said, it kind of balances the playing field. What is the the immigrant arguing? What is the government arguing? We're going to give them equal weight and see ideally, what did Congress intend?
Okay.
And I think it's funny when we look at, from an immigration standpoint, there is a lot of wide swaths where there's a lot of freedom for the executive to do things, and that's kind of discretion, or hey, do whatever you want with work authorization. If I am a pro-immigration administration, I can kind of push some things forward still through rulemaking. And I think there's a lot of places that they can still do that.
And that actually leads to one of the questions from the audience in the chat.
Great timing, actually.
Yeah, because they're asking how will it impact the H480 and OPT? Because
so I had originally brought that up, thinking it was kind of Chevron based, but actually it's one of those when you look at the text of the INA, they're very clear. There's a lot of authority for them to make regulations for work authorization. These, that they have. I mean, if you go read the opinions on the H480 and the OPT case, and those were, 2, maybe 3 years ago, I think.
Yeah.
COVID's a time vacuum for me, so I don't remember. But they weren't too long ago when those decisions came out, and it really hinged on the agency has this authority for work authorization that they can do what they want within, like Brad said, reason.
Mm-hmm.
It's why, Brad and I are talking about this, Friday, the I-140 EAD. Everybody talks about that.
Yeah.
I don't think that this decision prevents that. I think they can still promulgate regulations that say, look, we're looking at the INA and our inherent authority. We're going to look at, AC 21, which is all about portability and kind of giving some freedom back to people in the green card backlog.
Mm-hmm.
We're going to do that after X number of years. If you've got an I-140, you get an EAD. They can do that. There's a lot of EADs that are not statutory, and they're totally fine, even in a post-Chevron world. They just need to do it.
So, like, a follow-up question on that, like, and obviously, like, it's not necessarily you need to have like a clear answer for that. Is because I think a lot of frustration for folks in the EB backlog is, that with the recent parole in place by the Biden administration, there was nothing done for like, some of the kids aging out and, the EAD I-140 option. Is there a possibility of litigating that and bringing that into effect? Or is that a very stupid question itself in the first place?
So the first thing is the Biden administration hasn't done anything to implement the thing it announced 2 weeks ago, 3 weeks ago.
Yeah, there's nothing in the Federal Register.
Okay.
Policy guide out or anything.
I thought it was already implemented and in place. And
the only memo that took effect immediately was the asylum ban.
Okay.
Oh.
The parole in place is all just like, hey, we're going to do this. It was this announcement, we're going to do it. There's nothing for the anti-immigration folks that hate everything immigration. There is nothing for them to sue on today. It's just the administration said, we want to do this.
But he said 40% reduced border crossings and everything after he made that announcement at the border. So
I think it was more like an optics play, like when everyone was screaming that.
But at the debate center, I thought with the numbers, percentages that he put forward, I thought it was already in place, and it's a result of that.
So the 40% decrease in border crossings is related to the asylum ban, and that is implemented. That is happening immediately.
Okay.
The parole in place program is very much like one of my projects at home. I keep telling my wife, yes, I'm going to finish the frame for the TV. Ignore the fact that it's in 3 pieces over there for the last month. I'll get to it. I promise. I made a big announcement. I'm going to build a frame for the TV.
Oh, wow.
CNN carried it. CNN carried the announcement. You guys might have missed it.
Okay.
I think I was watching Fox News that day. I'm just kidding.
I should say, I'm sure they will. I'm sure they will.
Yeah.
I'm not saying anything negative or cynical. I would
Brad's
never do
being
that.
politically correct at this point. Yeah.
I mean, I think it probably was a talking point of the debate. So the announcement was made a few weeks before that. And he had something to talk about it, and got him some brownie points maybe.
I think it served its purpose.
Yeah, I think so too. Yeah.
That's the cynical side of me. But I will say to that point, going between that and the OPT stuff, going way back in history, right? The source of the federal government's power to regulate immigration is not in the text of the Constitution, right? If you go through the Constitution, it talks about the federal government can establish a rule of naturalization, right? But we know naturalization is becoming a citizen. It's not entering ingress and egress from the country.
Right.
So the Supreme Court has found that the source of authority to regulate immigration comes from the same pool of power that allows the United States to fend off invading armies. Okay, that's not just a talking point for one particular party.
Wow.
It's
That
called
sounds
the
harsh.
yes. It's called the plenary power doctrine, and a synonym for plenary is absolute. And so, because there's this deep well of power and authority to regulate in the immigration space, I think is what Stephen was saying earlier, is they get away with a lot. And courts don't use Chevron deference, but every immigration decision, I'm sure you guys have seen this, like, well, the judiciary has a very small role to play.
Yeah.
And that's the reason they say that is because the judiciary also has a small role to play on the battlefield in a military skirmish, right? Immigration is treated the same constitutionally.
But isn't that there is some level of ambiguity in that, right? The way it's described. I mean, if it's described the way that you've described right now, I mean, couldn't we properly define the playing field with now that it's the Chevron deference is struck down?
Say that again. I'm sorry.
You mentioned that the way it's like the words that are used in the Constitution describes a battlefield, right? Isn't there some sort of ambiguity there right now, because that was back in the day, and now the way it is right now probably the same definition would not apply for it. So
the problem is that all of the case law since the 1880s that's come out of the Supreme Court has built on that, and that's the fundamental basis for regulating immigration. If it had a provision in the Constitution, it would be easier to find its limits, right? But that's why the executive can stop a particular religious group from coming in the country, as we've seen in recent history, and the court affirm it, right? But it's the same power, right, that Stephen says. If the question is the authority to issue work authorization, that's deep and that's very strong. And so, while those opinions about OPT and such challenged it, I mean, there is a question of, and this does get into the Chevron stuff. Did Congress authorize the agencies to do this power? And in the work authorization space, I mean, maybe this is ironic, maybe it's not, but since 1986, when Ronald Reagan signed the Immigration Reform and Control Act, the feds have had power over who can work and who can't in the U.S.
Wow.
And it's incredibly broad authority. And so, I think actually one of the easier things for the agencies to do is to award work authorization to folks because the authority is so big. And I think the death of Chevron actually will help that a little bit.
Nice. So that's definitely a good thing.
We did have another question there, Brad, similar to with the topic we are. How does this affect the DACA folks? Would this affect the DACA folks negatively or positively? Everyone's
Steven's
smiling.
laughing.
Yeah,
DACA is such a, I don't even know how to put this right. It's such a
makeshift arrangement that was.
Well, it's a mess. It's really ultimately what DACA is prosecutorial discretion not to deport, right? And then because of that, they've granted work authorization and all that with it. And again, I think what's been there is, again, it's this inherent authority to do all these things. And I frankly don't do enough DACA cases to have followed all of them, because this law is, or not law, this policies Obama, right? Obama era. And God, we're still fighting it out. By the way, Judge Hainan in Houston here
is retired.
Retiring. Yeah, I meant to text you that today, Brad.
I saw that on the DACA subreddit, like somebody had posted about it.
Yeah.
So for those of you, I'm sorry, I'll let you talk.
No, so Judge Hainan was the original judge who ruled against the DACA, but also originally ordered all of the DOJ lawyers to go through ethics training. Every DOJ lawyer that took place took part in the case to go through ethics training for their misrepresentations in court. I don't think he was very fond of the DACA program from a jurisprudential side.
Well, I didn't know that
Yep.
background. Yeah.
Yep. A lot of folks hate him.
Just so you guys can empathize a little bit with Judge Hainan, for years he was in Brownsville, Texas, and if you kept me in Brownsville for that long, I would probably be real angry too.
Yeah.
Damn, Brad,
Yeah,
you know all the intricate details behind all the major law figures in America. It's insane. It's like, that was his aunt, that was his nephew, and then he stayed here.
Well, in my misspent youth in the Department of Justice, I thought it was fun to go to Brownsville, and there were two judges in Brownsville. One was a Clinton appointee, and the other was Judge Hainan. And whichever one got the case, that dictated who won.
Oh, wow.
Wow.
And it was I once did a week-long trial in the federal courthouse in Brownsville, Texas, where I learned the best salsa was at Chili's. Anyway.
Okay, not visiting Brownsville anytime soon, though.
Yeah.
All
But
right,
Sanjay, I will say to your point, DACA is a really interesting question under Chevron because it is it's not a regulation, it's a policy memo. And to announce a authoritative interpretation of a statute in a policy memo is very different than doing it through a regulation. Okay. But I think more importantly, bringing up something Chevron, this decision Loper did not do, is there's all sorts of other restrictions under the Administrative Procedure Act into getting into court. And challenging an action of discretion, which Stephen properly said, DACA is prosecutorial discretion. There's an entire other statute that says you cannot challenge those decisions. And the Loper decision didn't do anything to get rid of that. And so recent decisions out of the Fifth Circuit that one's called Chajati, and it dealt with advanced parole for high-skilled immigrants who had retrogressed. It basically, we went through all this litigation and they said, actually, this statute says you can't come in and challenge this. And so Loper has nothing to do with that. You still have to get all over these other hurdles. And so I love the brainstorming I've seen on X today about what can we do? What can we do? But it's still subject to all of those other really boring technicalities.
What I did find interesting, I know you and I talked about it today, Brad, was the Chief Justice talking a little bit about the judiciary, going back to my analogy that I used when you and I were talking about this last week, left and right limits, right, of discretion. And just to put this into perspective, Brad and I were in the Fifth Circuit on the retrogression hold policies in February here in Houston. And, the Department of Justice, the government's discretion, we shouldn't even be here, discretion. And Justice Willett, a former Texas Supreme Court judge, goes pulled during the Trump administration over to the Fifth Circuit. Used to be really great on Twitter before he went to the federal judiciary. Asked them how far, because ultimately our challenge is that, yes, you have discretion, but your discretion has to follow the law. And, that's a very simplistic way of arguing our case. And they're like, just discretion. We've got discretion over everything. And I can't remember the phrase he used, but basically he asked, can your discretion be used? Do you remember the phrase, Brad?
I thought he just straight up asked, could you deny all African American or all black people in the name of discretion?
And the government's like, Judge, we would never do that. Well, would you deny? Could you deny all Catholics? Judge, we'd never do that. The question isn't, and what he said, he said, the counsel, the question isn't would you? It's if you did, is that discretion that the court could review? And they said no. We have that
Oh,
authority that if they wanted to, and again, a lot of respect for the lawyer on this. It's, she's not advocating that they would do this or that this is a good
yeah,
policy.
yeah.
Justice Willett uses two very extreme examples to try to show.
Yeah.
And I think the Chief Justice and what we call dicta, meaning it's not really the meat, it's the side dish maybe of this case of maybe courts do need to be able to put some guidance on what is good discretion. And I think Justice Willett kind of hinted at that here, and I don't think Chief Justice Roberts looked at his case and did this. I think they're two similar legal minds that, yes, there's a lot of discretion. I know we're focused on immigration, but the EPA has a lot of discretion. All these agencies, there's discretion built in different places by Congress. But
yeah, another big one I saw next was ATF. There's a lot of folks talking about ATF and how they want to be pretty hit after this.
I have some ATF ideas, but Brad doesn't think they're as funny as I do with immigration and how ATF prevents people who are non-citizens from owning guns unless you're doing it for hunting, which, as a Texan, right, I think is faulty.
Okay, I'm going to just go back to the DACA discussion because one of our viewers had just a question is they are a DACA recipient and they were asking is what are the odds that a future administration can go to the Supreme Court and close that path, close DACA itself? Does the Chevron ruling have any sort of connection with something like that? And again, this is an open-ended question, I guess.
Sanjay, wouldn't, even if it was not there, it was a new administration could come in and impact that, correct? Even if
that, I guess, they can always go to court, and I think the Trump administration had done it in their previous term. But yeah, I'm just relaying the question from the audience members so that one of you can answer it.
Yeah, the Trump administration rescinded DACA in their first year in office. Advocates, actually, I think it was the University of California, challenged the rescission, and the entire DACA decision, or Regents of UC versus DHS, is about whether they have authority to do it, and all of those really boring, what I think are really fun, APA doctrines. And the Justice Roberts wrote the decision and basically said this: there's two parts to it. You're saying it's all one, but you didn't consider it two separate parts.
Yep.
Okay.
And so send it back and consider it. But realistically, if you look at his review of it, it was they would say it's only you're only supposed to give a 5-foot deep review. His review of it was 30 feet deep. And so you can kind of read into that a little bit that the court was taking care of it. But I fully expect if there's another Trump administration for them to rescind it again, because the dissents in that case say this: what's the point? Why send it back? We've told them you can rescind it. You just have to do it properly. So this is a waste of everyone's time. So now they've got the roadmap of how to do it properly.
Okay.
How did there was another ruling by the Supreme Court today, right? The corner post ruling.
I thought corner post
impact anything from an
I actually had texted Brad this morning when I saw that. I think corner post is a little bit more interesting, to be honest with you. Which I'm sure most people are like, come on, Stephen, everybody's talking on the news about the death of Chevron. So typically there's a 6-year statute of limitations to challenge regulations. And what this was is, and Brad and I talked about this. He's had cases where they don't, the judges don't always hold to it, because what this case did, the case today did, is that you get some time once you've actually been injured, once you've actually been harmed by that regulation. So just because the regulation was in 19 90, right?
Yeah.
And, you can't just sit there and say it's a hard and fast rule. Well, come 1997, nobody can challenge this anymore, right? It's been more than 6 years, because the flip side to, litigation, first semester law school is you can't really litigate until you've been harmed, or at least alleged harm.
So I was telling Steve when we brought this up, the IT serve case that my old firm litigated with friend of the pod, John Wasden. So when he and I worked together and wrote that brief, that was something the government argued hard, because we were challenging a policy from 2010 and a regulation from the 90s. And they said, nope, statute of limitations. And but because of the policy memo in 2010, it had taken on a new look, and the judge said we could challenge it. And so it can make a huge difference in the employment-based space, because, again, one of the areas it's fun to talk about right now is EB5, only because there's a brand new statute out there, right? And any new statute, no one knows what it means, even the people who provided it to the senators to get it passed. And the regulations that implement EB5 are from 1994. And now they have a statute from 2022.
From 1994,
Wow.
EB5?
Yeah. It's a very recent. I mean, I don't know what recent means here.
Compared to 1965 overhaul, I'd say 1994 is pretty recent.
It's very recent in the immigration context. Yeah.
Yeah.
Canada's like, hold my beer.
And I actually missed one of our viewer questions is, so the PERM delay case that you folks are involved in right now,
Good question.
does this help with that or not, or is it too early to tell, or what can you talk about it?
Just to give some context to the folks, these folks are trying to actually litigate the government and reduce the PERM delays from what I think is like 13 months right now down to a reasonable number. I don't know what reasonable is anymore. These guys, I see posts saying that it probably takes them 10 to 15 minutes, but we wait 13 months to get it.
8 to 10 minutes.
8 to 10 minutes.
Yeah.
So
just wanted to give some context to these folks.
when they created, and I'll let Brad discuss on how this case goes about, but kind of some background here. When they created the PERM process in 2004, the original proposed regulation said, we can get this done in 21 days, and we expect 100,000 cases a year. Okay, and I like to emphasize those numbers because everybody thinks there's this like dramatic increase in how many PERMs, and it's true. There is a lot more than there has been than there was in 2004.
Right.
But they predicted 100,000, right? And I think our highest number in the last 5 fiscal years was 120 something, which isn't a huge increase. And so when they finalized the PERM rule, they said, well, 45 to 60 days, guys. We could do it in 45 to 60. Okay.
I'll take it. I'll take it.
Right? Like, who wouldn't, right? When 45 to 60 days is a lot better than 13 months. And we talked to some attorneys who have been doing PERM for a long time. They used to tell us, I hear these stories of we really weren't PERM wasn't as tedious because, if it gets denied, your ads are still good. You go ahead and just rerun the PERM, right? The ads haven't expired. So you'll get a decision in 2 weeks. Then you just refile. Who cares? You're back, a couple weeks, but, that's not the end of the world. So now we're at 13 months and this 8 to 10 minutes thing. So when we deposed the, I don't know, what's his official
laugh over there. I see Brad laughing.
Yeah, this guy, and anybody that watches college football the way I do, he reminds me of an SEC coordinator who's, this is the system. The system is the system, and it's the best system. And no, I know we're not scoring touchdowns, but the system works, okay? And this guy, really, this is his baby, right? He's created this process. He's been in charge of it. And we asked him, how long, does this take? And they are contractually obligated to, do what, 45 to 50 a day, which comes to about 10 to 13 minutes. And we're talking about the 10 to 13 minutes. He said, I want to be clear. Last fiscal year, my team, 8 minutes. They did them in 8 minutes. And so
You
the
did
rest of the conversation in the deposition, Brad, be like, well, when we talk about the 10 to 13, 8. We did them in 8. And so you think about these perms that take months to prepare and months to decide, and they're doing them in 8 minutes. Okay,
187 days last I checked, which was
so just to kind of put this into perspective with why we're challenging, and then we also had hired an expert long before we were litigating to kind of analyze, because we wanted to build our case around a theory right beforehand, and we sent it over to a statistician and said, what does this data show you? And here's some of the things that we tend to see in these cases. What does the data show you? And he's like, oh, this is like first grade statistics for him. So anyway, so Brad, Chevron for delay cases, what do you think?
So well, first off, I really don't like you guys bad-mouthing Department of Labor. They
Wait, I don't know if this is a joke. There's
Brad's trying to get brownie points.
I have a fan account on X, DOL number 1, 17. And they have a really hard job. So when they get those ETA 9089s, they're not allowed to look outside the 4 corners. They can only look at that document. And they have to go all the way through it. And it's like an 8-page. I mean,
oh my God, Brad, I feel bad for your students, man. Oh my God, this was sarcasm in class.
I know. I'm like waiting for the punchline to come.
And it's so smooth. Someone tuning it for the first time is going to believe that you're on their side.
Yeah.
It is so hard. A year? I mean, it could take longer. That's all I'm saying. But so Chevron in the delay case is an interesting question, in my opinion, because there's really only one factor that looks at the statute, and that's congressional intent on how long this should take. And in our case that we have in Boston, which is what we're really pushing, and the government's response has been mind-blowing. I mean, I don't know how to respond. One of the arguments they don't really want to engage with is there is no timeline in the statute. Congress did not come in and say, hey, it should take 60 days. Fair enough. But what Congress did say is the whole point of this thing is to make sure no lawful workers at the time of the application are able or willing to take the job. Okay, that's a paraphrase of the statute.
Okay.
So if we're looking now to congressional intent and looking at the statute and ignoring what the agency is saying, how long can they take on a perm and still achieve that goal? So in other words, if I test the labor market today and then I file my I-140 14 months from now, are they actually protecting the labor force, or is that delay undermining very clear congressional intent?
Could that come back and bite us if someone goes back and says, hey, when you guys filed the PERM and when we actually approved it, like you said, it's a 14-month delay. Could they can say, hey, there could have been a potential candidate and this kind of invalidates?
No, because they're very strict about the regulations on the recruitment process. And as long as that's met, it's not anybody's fault except DOL's that it takes 13 months.
Okay.
If the company has gone through and done the labor market test, done the stupid 2 Sunday newspapers, that is definitely where high-skilled, degreed individuals are getting their jobs from in 2024, right? Is the Sunday newspaper.
The Brownsville Gazette.
By the way, the last time I bought a newspaper was the 2022 World Series. Right? The Astros won, so I could have
the Astros won.
So I could have the sports pages.
But I do think it helps our case because when the delay undermines the agency's entire purpose, it would tend to show that delay is unreasonable.
Yep.
And with Loper, I think we can really nail that in the coffin. And the fun part about that is now, although we're on opposite sides, we're arguing to help strengthen, right, the labor market test. You know, it makes us sad that it takes 14 months because we want a legitimate test, timely test of the labor market, as we all do, right? Because it's not like there's millions of jobs out there open that no one can fill.
Yeah.
For folks who still don't understand that is just Brad being sorry. There is like it's the lowest unemployment rate ever. Like the people are scrambling. There's just not enough people in the US.
Basically, buy a newspaper if you want to find a job.
Yeah.
My favorite irony of that is who's the one that reports the unemployment or all those really low rates? The Department of Labor.
I had a question.
I do think there's some positives that come out of this. And I think I said the big thing is, you know, I think there's a couple of misconceptions in my mind. One, this does not prevent any sort of regulatory process. And I think, when I saw people, this is the end of the regulatory system. You know, the EPA is dead. We're just going to have, it's all, no. They can still make these regulations. We're just on even playing field.
I had a question, guys. It's not ambiguous by any way, but someone asked it, and it's a question that I thought, and a question a friend of ours, Padma, had asked once. We get 140,000 green cards allotted every year, right? 7% for every country, right? What if? I mean, if you take that 7%, that's like around 9,800 visas. And if you have 14 countries with 9,800 applicants, you've essentially finished up that 140,000 visas, right? Then what? Like, what happens then?
That's the point of singularity where this light doesn't escape and everything goes away. Like,
I mean, 7% for every country, but 140,000. And if you have, the math doesn't math.
Well, I think there's something. I think Congress is going to have to eventually look at things. And I know this isn't probably what everybody wants to hear because everybody knows Congress is god awful about creating laws, especially around the space of immigration. But for the first time in a long time, we're starting to see backlogs for everybody. And it's not just one or two countries. And I tell backlogs are terrible. I think they're terrible everywhere. But the worse the thing is, especially in 2024, we're a more global marketplace, and that's all. Again, this has always been my frustration with Congress: is we're regulating immigration based off of laws before the internet, right? And so I think
that's why the newspapers.
Yeah, right. Like we're doing freaking newspapers, right? And I think just now that you're seeing priority dates and retrogression on the rest of the world, Congress is going to have to take a look at, is this the way this should be?
That's being a little too optimistic.
I can't tell you the amount of times Brad and I talk and we say, in a sane world, this is the result, right? Or in a sane world, this is what happens. And it's not the case.
So someone I follow, his name is Cyrus, right? I love his blogs. I think he's a historian.
Cyrus is an incredibly smart guy.
More than anything, he put something in that made me think about it. He said if the Chevron ruling is overturned, it has a negative impact on another ruling called Brand X. Could you guys give us some some info on that and how it would potentially impact immigrants? Because he said his own words was Brand X is a double-edged sword, and it has been used to help immigrants in terms of policies in the past. And if that goes away, there could be a potential impact for us.
So I'll just say this about Brand X. I don't want to go into the details of it because it's too late. I will fall asleep talking about it. That's how boring it is. But it's an application of Chevron deference. It's if this situation happens, this situation happens with Chevron, this is how you apply it. So you can crumple it up and throw it in the trash. And there's about 5 or 6 cases from the administrative law casebook I teach out of now that you can crumple up and throw away because their entire reasons were to interpret Chevron. But I think Cyrus's point is proper. Chevron does cut both ways. And I think that's why Stephen and I, when we started to see everyone kind of celebrating, we're like, well, for some things, yes. For some things, no. Right. And I do want to know, I want to just read one little thing to let you guys know that I do think there's optimism here, because if we're returning to the text of the statute, and that's the prime thing that courts are going to look at, even the parts that talk about EB1s, EB2s, right? This is how they read. Visas shall be made available. Shall.
Yeah.
Right. In a number not to exceed whatever percentage, but it is mandatory, right? They shall make decisions in priority date order. That's another statute. They shall accord the same status and order of consideration to derivatives. And so I do think getting rid of Chevron will help enforce that mandatory language, which I think short of legislation, we can use litigation to avoid wastage. Right. Because if we're actually using 140,000 a year or whatever it is each year, that's a huge step forward.
Yeah.
And I had a couple of questions. One was a follow-up on the PERM delay. I mean, so the idea that you mentioned that, the Chevron ruling with unreasonable delays, could that same argument be used against USCIS's long processing times for, other paperworks? I don't know, EADs or whatever it is.
I mean, Chevron has limited application in the delay context because it really delays are all controlled by what is reasonable.
Okay.
Right?
Okay.
So your guess is as good as mine. In the Department of Labor one, that's just an argument that we're making, that we're really pushing because I like it. And it fits with our timeline we're pushing of 60 to 90 days. Right.
Okay.
But
so
and
EB1 criteria, Sanjay, is probably another thing that a lot of people have been saying that could be positively impacted by the Chevron rule.
Yeah, that
because that is like very ambiguous on what makes someone extraordinary or not.
correct.
Someone posted recently that their client was pulling in an annual salary of $5 million a year. And
yes.
It's did you see that? It's still
on LinkedIn. I think some
LinkedIn,
lawyer.
It still didn't qualify though because USCIS is like according to us.
They weren't there on the Google search or something like that, right? They searched them on Google.
We don't think this is a high enough salary, so you don't meet that criteria. And
that one other question from our viewer, Ame. With today's Supreme Court decision on presidential immunity, there are now virtually no limits on what a president can do. Does that provide more leeway for POTUS to sign an executive order with regards to the backlog?
Sanjay, we're already getting green cards with our degrees, man. What more?
Remember there. Well, hold on. That was like the first announcement, and then like 24 hours later, like whoa.
Extensive vetting.
I haven't gone through much of today's immunity decision because I wanted to stay away from it. But immunity for criminal actions is a lot different than saying you have authority to do something. And
okay.
The discussion today with presidential immunity is, can you be tried criminally for official presidential actions, whatever those might be? Because I think that's kind of how the open-ended question the Supreme Court left. It's like, what is an official presidential action?
Okay.
If, let's say, a administration just decided to sign a pen, take a pen, and say, green cards for everybody, I think there's an argument that violates the text of the INA. That's not, he can't be tried criminally, right? In Texas, where they're trying to pass their own criminal immigration laws, right? I don't think you can try them criminally, but those things still have to be there. But I still think there's a lot, and this is one of the things that's been my theme. There is a lot of things the president, the executive, can do through administrative action. When Biden was doing this parole in place, one of the things he could do is sign an EO saying, approve the 601 and 601A waiver.
Yeah.
Right?
Yeah.
Those are taking how many years now? 2-3 years for 4 years.
Yeah.
For 601, 601As. The president can sit there and say, we have all this discretion. We're going to exercise it to approve it, except if there's a national security issue or a crime and moral turpitude.
Yeah.
Okay. And that gets rid of that backlog of people who have LPRs or citizens, relatives.
Okay.
But it's the same thing. I-140 advanced parole and EAD. They could go through the rulemaking process. And, one of these, I don't know, months back where Brad and I were just kind of, well, how would that look? Well, we're interpreting AC 21 to allow for this. They can do that. Again, I think my big thing is it's not the end of the regulatory paradigm. It just kind of changes how things are fought in court.
Right.
I think we're hitting at an hour mark. Sanjay, I don't know, you got one final question and you want to close it?
So I guess you probably are going to get a lot of calls and emails from folks like, yeah, it's time to litigate. Let's get the swords and chopsticks out. And
Chopsticks.
it's
Yeah.
I was on a call today with somebody and with a group, and somebody was like, yeah, I'm not going to go ambulance chasing around Chevron. And I think that is, something Brad and I talked about is I think I'm all for let's challenge things where we can challenge them. But I also don't want to just have people have false hope and, buy into something that has no look, I'm all for it. Let's take a tough case that might be novel. That's great. Let's do that. But it's got to have some legal ability to be successful. Otherwise, I think it's, something that I think there's a big possibility of people being taken advantage of that are
that's the other side, right?
About
a lot of folks just saying, hey, let me help you.
Yeah, look, I mean, or hey, I saw you posted about let's sue on getting rid of this EPA guideline. Let's do it. And remember what the Loper case is about. This is probably one of the silliest things I've ever seen. Basically, there was this mandate that these boat inspectors, federal monitors, were on these
$700
Atlantic herring fishing boats, and the companies have to pay for all of these.
Yeah, it's like $700 a day.
Monitors on their boats. So,
but it's pretty cool, right? I mean, think about it. A small group of fishermen from New Jersey bought down this doctrine that's been there for 40 years almost, and
paid for by the Koch brothers.
Hey, look, those fishermen went on to just get the feds off their boats. Look, if Koch brothers are going to fund it to get rid of Chevron.
Not that there's anything wrong with that.
and even the corner stop, right? It was just a small truck stop that just decided that it wasn't fair, and they actually fought through it. So I'm optimistic, guys. I don't know if the small guys can actually bring about changes like this. You never know. Yeah.
Speaking of small folks and small words and small changes, Brad, there's one question on the AOS retrogression case. It seems is it going to the Supreme Court?
So currently, a petition for certiorari is pending with the Supreme Court. That's a request that the court hear the case.
Okay.
The government's response was due July 5th. They got an extension, which is pretty normal. Okay. I think we'll know by the end of the summer whether the court's going to take it. It's a long shot. Every case is a long shot of the Supreme Court. If they take it, the case is designed to get around Chevron. So
Oh,
Loper won't really impact it. It's already kind of built into it. Again, I'm optimistic. I'm still hopeful. There's still cases pending. We'll see. It's definitely something I still work on every week in different places. And so to answer your actual question, yes, it is pending at the Supreme Court. And we'll see.
And what I think is interesting, this is, I try to keep positive on those cases and try to hope for something. The fact, we had a number of cases this term from the Supreme Court of the judiciary trying to rein in the administrative state, whether we talk about Loper, whether we talk about the case, the truck stop case from today, whether you talk about the SEC, was it Janikowski or something like that, the SEC case about, the SEC can't be the administrative law judges, and it needs to be heard in an Article 3 court. It shows kind of one of the things Brad has been preaching to me about this is we have a Supreme Court that wants to rein in the administrative state, pro or con, good or bad, and I think that's where I think that there's some optimism, cautious optimism, right, with the retrogression case, just because, truly from a statistical standpoint, the number of cases petitioned for review at the Supreme Court that get selected to be reviewed is incredibly small. Whether it's, this matter or whether it's, there was a case that I couldn't believe that they denied cert on a couple of weeks ago because I thought it was a big nationwide issue. It's a small number of cases they take, but the fact that they're trying to rein in the administrative state is interesting to me. And I think it's what gives me some cautious optimistic about Brad's cases, about the cases that I helped with a little bit. Not nearly the level that Brad did.
Stephen only helped with the ones that won.
Oh.
the one, yeah. Well, oh gosh, I thought I did that, Brad. But really, no, it's, this has really been a very interesting case that I thought, I don't know, I think it's very interesting from a text structure history standpoint. And I've seen some theories about this, about the difference between current and available, and we'll see.
Cool.
Nice.
Well, good luck, guys. There's a lot of people sitting in.
Yeah, I know. And I think,
I
and
hope you guys knock that out of the park. Yeah.
And I think I speak for a lot of folks, at least from a lot, what you've seen to you folks, both of you do amazing job, not just at educating everybody, but doing the good fight. I love it.
Yeah, 100%, 100%. And just a plug for Steven, he runs his amazing Telegram group as part of his firm, and I've never seen someone be this prompt in answering questions. So
I got a third screen. I ended up getting a third screen for my social media. So
I wonder how you're top of X, Telegram, everything. I was like, how does he keep up?
Yeah, I've got
and YouTube.
I've got my email and then what I'm working on, and then I've got all my social media stuff. I got a third screen because I was I need to do that. It also helps. I got young.
You have
kids
a compliment, Steven, from Sanjay. Steven is the man.
Like to watch their TV shows, and there's so much of Super Kitties you can watch. I think that's the one we were on today, and so I just kind of enjoy scroll through some Telegram, try to help people out. There's a lot of times, people have questions that are quick and it's easy, and they don't need to go, pay a lawyer to, go through a 30-minute analysis to a yes question, right?
The thing, Stephen, is a lot of people would actually do that. Say, hey, book.
So that's trust me, I know. And look, I think there's some things you should talk to more in depth. I think there's some in immigration that are very complex, but hey, what's the deal with my case? Here's kind of some of the things. It's okay.
And Brad's got his Pro Say Pro tool on the side too. So it's, I
by the way, John Moy says hello. I had lunch with him today.
John. I mean, I told this to John during the recording. Like, you guys are like the Napsters of the attorney world, you know, like give things for free as much as possible. So thanks. It does not go unnoticed, and we appreciate everything we do, and we love you guys.
And we give you viruses. This is good.
Yeah.
Well, thank you guys for letting us join y'all tonight, and it's been fun.
Thank you.
Thanks again. Y'all. Have a good 4th, and hopefully see you guys soon.
Y'all have a good one. Take care.
All right.
Thanks.
Thank you, folks.
Gonna end the stream.
Yep.
And to everyone who stayed back till now, thanks for sticking around. Appreciate it. And yeah, hopefully see you guys at the next live stream. Take care, guys. Good night.
See you, Brad. Whoa, we had, I think, 50.